and Bremner, they passed Drew's law to try to bring in some of this hearsay to bolster their case. They did all this, all these mechanisms, all these filings, losing in the lower courts, bringing the appeal, and they missed the deadline by 2 weeks. They don't even look at the merits. They missed a deadline. Is that surprising to you?
Unbelievable. I mean, our whole job, Ryan, as you know, is about deadlines as lawyers. Missing a deadline is just shocking in a case like this. And, you know, as your viewers may not know, interlocutory appeal is one that you make before trial. And so these are really important, quickly moving appeals that are crucial if they said they couldn't even prove their case without this evidence, the hearsay and other evidence that you've talked about. But it's not just hearsay statements. It's also what it would have cost him to go through a divorce. It would go to motive. And as you stated, other acts of domestic violence and statements from Kathleen, his ex-wife, that, of course, that he would kill her and make it look like an accident. So, and other hearsay statements, and some that we don't know yet in terms of what would be used in a trial. So it's huge. And I assume they're going to pursue this appeal because they need that evidence in the case.
I wonder what they can appeal. If they missed the deadline, they missed the deadline. What's there to appeal at that point? Well, the upper court would say the same thing.
Well, yeah, except for as I understand it, and of course you can hear from counsel who's intimately involved in this, but I think there were 3 interlocutory appeals, and there's missed a deadline at least on 1. But the fact is, certain of the merits were considered, as we know. And I'm sorry to cut you off.
That's correct. There were 3 appeals. They missed the deadline on 1. But it took this, you know, the appellate court didn't just rule on the technicality. Even though they effectively dismissed, said you missed the deadline, they still spent, you know, over 38 pages reviewing all the testimony and everything else. And they found that, they didn't find that Judge White had done anything unreasonable in keeping those hearsay statements out. So it's not merely on the deadline, even though that was the dispositive issue. But, you know, I mean, listen, they made 3 mistakes that I can see in pursuing this case. First mistake was that they passed that statute rather than go by the common law of forfeiture by wrongdoing, which is the way to get evidence in. Then when they got halfway down the path, they tried to switch from the statute to common law. And that was a mistake because that really messed up the record and made everything a little bit murky. And then the third mistake was obviously filing late on the appeal. So it's just a series of mistakes that have been made in this case, and I just would hope that the best way to clean this up is to dismiss the indictment.
All right, so Joel, if they don't dismiss,
maybe start from scratch if they ever get new evidence.
So Joel, if they don't dismiss the indictment, what's next for you in this case? What happens next?
Well, either we wait and see if the Supreme Court's willing to take it, if that's the route they go, and if not, I've been discussing trial dates with my team when everybody needs to move their schedule around a bit, and when we can get all 5 lawyers into the courtroom to try this case, and I'm hoping we can do it before October.
All right, Joel Brodsky, great to have you with us, and Bremner. I know you're going to stick around.